Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examination. In today's discussion, we will take up some of the important articles which are important both from your pre as well as your mains examination perspective. Let's get started and look into the first article. The first article is speaking about Right to Information Act. This is important from your GS paper 2, which is governance. Let us try and understand what is the author trying to convey through this article. The author as a whole goes on to say that Right to Information Act has been able to bring massive transformation in the country when it comes to the transparency and accountability. However, there have been massive number of issues that has been arising of late, primarily because of couple of grievances which has not been addressed. One is on the structural front, the other is on the basis of the rules, the third is on the basis of the law, and also because of lack of cooperation from the authorities. Let us try and understand what is the intent of the author. First, we have to understand what is this right to information. When we speak about the definition of right to information or what is this information all about, let's assume for a moment that you are a person who is paying the taxes. What does the government do? The government imposes taxes on you and you are paying your taxes. It can be in the form of income tax, or let's say you're buying a product. You're buying your phones, you're buying your mobile phones, you're buying your cars, you're buying any other product. What you will also have, it says inclusive of the taxes. So you are paying taxes and you should also know where is your tax money heading, what is that the government is doing with your tax money, how do you know about it? That is through the means of the Right to Information Act. So the Right to Information Act will basically allow the person who wants some information from the government to seek information from the government, since the government has its own tools and operations. Let's say for example, it has to find out how much income you are generating. What does the government do? The government attaches your PAN card with that of your bank details. And at the same time, let's say you're buying a property or you're making use of your money for something else. So the government is asking, where did you generate this income from? Similarly, since you are the taxpayer, you should also know where the government is investing this money. How will I know about it? That is where you can seek the information. So what is information? Information basically means any material in any form, including records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material, held in any form and information relating to any private body which can be accessed by a public authority under any other law for a time being in force. So you need some information with respect to the government that can be sought by an individual with respect to the information. So what is the right? The right is to know what is the government doing, where is the money being spent, what is this rule all about, what is this circular all about, what is the law in place, and questioning the government about its mode of its operations. So the information includes all that we just read, and we are seeking information from the government to get this aspect so that there is transparency and accountability into picture. There was one of the comments, or you can say quotes, given by Mahatma Gandhi. He said, the real Swaraj will come not by the acquisition of authority by a few, but by the acquisition of capacity by all to resist authority when abused. So this was the definition or a comment or a quote given by Mahatma Gandhi ji, and he would be happy that the Right to Information Act is present. And as we all know, there is a simple definition of democracy. What is democracy? It is government of the people, by the people and for the people. But this definition of democracy had also changed as well. Government of the people had become government of the people. So they were not able to know the reality of what is happening in the society. Government of the people, by the people had also become by the people. So government by the people is, it is by the people as the people who vote for their representatives. But here it had become by the people, buying the votes. It had become by the people. And for the people had become far away from the reality of the people. So the people had some expectations, they had some idea as to how their country should be run, but then the politicians and the political masters were far away from the reality. In order to bring all this under check, what we have is the Right to Information Act, which was introduced back in the year 2005. Earlier as well, in the year 2002, attempts were made to introduce Right to Information by the Vajpayee government, but the real act came into implementation in the RTI Act of 2005. What has the Supreme Court held when it comes to the RTI Act? The Supreme Court in the state of UP versus Raj Narayan has ruled in favor of state of UP versus Raj Narayan that right to information is implicit in the right to freedom of speech and expression, explicitly guaranteed in Article 19 of the Indian Constitution. Subsequently, the court also affirmed this decision in numerous cases and has even linked the right to information with the right to life enshrined in Article 21 of the Constitution. In People's Union for Civil Liberties versus Union of India, it was held that right to information is a facet of the freedom of speech and expression as contained in Article 19 of 1 of the Constitution of India. Right to information thus is a fundamental right. In K. Ravi Kumar versus Bangalore University, the Supreme Court held public authorities cannot completely deny any document on the ground of confidentiality. Thus, the right to information may be taken to be a basic right to which citizens of a country aspire in the broad ambit of right to life under Article 21 of the Constitution of India. This has been the stand of the Supreme Court of India when it comes to right to information. So the Supreme Court in a nutshell has said that right to information is part of the fundamental rights. Right to information is part of the freedom of speech and expression under Article 19. It is also enshrined under Article 21 of the Indian Constitution, says the Supreme Court of India. So what is right to information? It is the information that I and you can sort out, and this information can be sought out because to bring transparency and accountability. Now the question is, should all kinds of information be given? Not necessary. Let's say for example, there is an information which is to do with the security of the country. For example, there is an investigation that is being undertaken by the Central Bureau of Investigation, or there is certain information which is about the sovereignty or the security of the country. In that case, they can deny the information with respect to all these authorities that have been envisaged under Section 24 of the Right to Information. So all those authorities were for them to safeguard for the security related purposes. Such information cannot be given by the government to the people who have been asking for such information. However, there is a catch as well. What is this catch? Let's say for example, there is a corruption scandal involved. Let's say for example, there is lack of transparency in the operation of the CBI. In that case, where corruption is involved in the CBI or any of these authorities, in that case, they need not have to give this information. That means they should be need not have to give information in terms of security, but in terms of corruption, they have to give the information. For security, the CBI need not have to give the information, but if it is to do with corruption or any of the scandals involved in that particular authority, in that case, they may have to give out the information under the right to information. Now, the author in this particular case goes on to voice out that there are a couple of concerns with respect to the right to information of late. Yes, right to information is a landmark. Right to information is a landmark legislation. It has an idea to perforate what is called as the transparency and accountability in the system. Yet, of late, what we are witnessing is couple of issues and concerns with respect to the Right to Information Act. What are these concerns? One, the author goes on to say that as we discussed, we have some of the authorities which need not have to give information in terms of the national security and sovereignty. But then you have the public information authorities who have been designating such information of late into too many in nature. So there are only few authorities, there are only few pointers which have to be taken into picture under Section 24. However, many information is classified as information related to national security and sovereignty. So you file an application, so you find you take the public, or you want to file an application, you give it to the public information officer in that particular place, and the public information officer should ideally give you the information. But what does he do? He denies this information. He gives this information that you are asking for and tags it to the national security and sovereignty, where information need not be given. So in most of the cases of late, what we are witnessing is a tag attached to the information being sought, primarily because they say that this is the information that falls under the national security and sovereignty, and hence it is being denied in most of the situations. The second argument the author brings into picture is with respect to the personal data disclosure. Let's say, for example, we have the Digital Personal Data Protection Act, which has of late denied the information because this is the personal information. What is personal information? Information which is personal, which means to say that information can be denied. Why should it be denied? Why is it being denied? Because this is not used for the public data. For example, if there is a particular information which has repercussions for the public, then such data can be given. But then most of this data is being categorized as the personal data, which does not have any significant impact on the public. So if those information which does not have significant impact for the public, where the larger public interest is not attached to it, in that case private information can be withheld. So this article says that whenever an information is sought about an authority, about an individual who is acting as a public authority, this information is denied, primarily saying that this particular information is not required for the public interest. Let's say, for example, I am a person who is corrupt. I have assets worth around 10 crores, 20 crores. But what is my salary? My salary is around 45,000. My salary is around 50,000. My salary is around 55,000. But someone else files a RTI and he asks for the RTI, give me the personal assets of this person, so and so. Hypothetical situation is what I am giving. So ideally they should be giving out the information, but hypothetically, if that authority so decides that this information need not be given because it is personal in nature, despite having the public interest, this person is not given the information. That happens to be the second major grievance. The third is that as a result of this not given the information, these public officials are also evading accountability as well. Ideally they should be giving the information. If they don't give the information that is elicited by that particular person is not being given, and as a result these officials are evading the accountability. The union government has the unilateral power in deciding how long the information commissioners stay in that particular role. We have had a major amendment as well. Earlier they were not supposed to change these terms and conditions, but of late the amendment has brought in a picture where they would also be able to decide how long the information commissioners stays in that office, which means, let's say we are asking for an information from an information commissioner in that place. So what exactly happens? This information commissioner and its body will have to give the information. But what if that information is against the government? In that case, the information commissioner, for example, will know for the fact that this is the information which is against the government. If he gives this information, the government may transfer him, so he does not want frequent transfers to take place. Ideally, if this person is given protection, he may give out the information, but since this person will stay in that place on the whims and fancies of the executive, he can be transferred to a different place, he may not give out the information. So the unilateral power is also being given to the central government, where they would be able to transfer the authority from one place to another. So in an apprehension that this information commissioner may be transferred, he may not give out the information as well. Apart from this, we also have the subordinate rules, and these subordinate rules are made by the state governments as well. So the state governments have the power to make subordinate rules, and these rules are again the executive rules, not by the legislature but by the executive, and they make these rules, and these rules are most likely to comfort the executive, and such information may not necessarily be given as well. Then what we have is the mode of payment. Let's say for example, if you have ever made the RTI, let's say you have an information. I have filed couple of RTIs because I work as an advocate. I may require some of the information from some of the government departments. How does it work? What you have to do is you have to buy the postal orders. What is this postal orders? It is just a copy from the post office saying that you are taking this postal orders basically to get the information from a relevant department. So you buy these postal orders from the post office, and after you buy this postal order, you also write in a piece of paper what is the information that you are seeking for. Let's say for example, I am seeking for the information about this circular. Are there any recruitments that are ongoing with respect to the government making use of these circulars? So you have some question and you ask this question, you write it in a piece of paper, type it in a piece of paper, and you attach this postal order which you have picked up from the post office, tag it and give it to that relevant department. Apart from this, you can also file this. Apart from this, you can also pay the fees online as well. But in couple of states, what you have is these postal orders may not be present, but then what they have to do is pay the court fee stamps, and this can be only purchased at a courthouse. And in some states, there is request for the demand draft as well. What is the issue for the demand draft? In case people have to buy the demand draft, let's say the Indian postal orders, it will cost you around 10 rupees. All that you have to pay is 10 rupees, and ultimately you will be given that postal order. You have to attach that with the letter, and ultimately you will be submitting that to the relevant department. But in the demand draft, let's say it is for 10 rupees, you may have to pay extra charges. Sometimes it goes up to double, most of the times it will not, but you have to pay extra charges for the demand draft. So the article goes on to say in couple of states, the Indian postal orders are replaced with courthouse, that is the court fee stamps, and in few states there is requirement for demand draft. This ultimately reduce the opportunities for the people because it is a cumbersome process. So if it is postal orders, you would directly go to the post office and get it. If it is paying via the internet, you will directly go and pay it. But in few cases, there is requirement of court fee stamps, there is requirement of demand draft where the amount is far more. In that case, people will not be happy to pay such an amount, and as a result, this is another issue with respect to the right to information. Then there are tardy appointments of the Information Commission. Despite the Information Commissioners need to be appointed, the government has not been notifying the Information Commissioners in couple of places. Many states do not even have an online portal. So these online portals basically provide a window of opportunity to file an application online. That is not provided once again by couple of RTI portals. Then Union government are on the portal. Filing applications has also become harder as well. Facility to create an account has disappeared, and the site forces all users to enter a particular areas fresh every time when an application is made. What do you understand by this? Let's say for example, there is a portal. This portal will basically ensure that you will be able to file an RTI. You would have already entered your information. Let's say for example, my name is Ajay. So what do? I give my details as Ajay in that particular website. I give my phone number. I give my occupation that I'm working as an advocate. I also give my email ID as well. So this particular information is saved in the portal. So all that I have to do next time is give in my login details, and the information is already given. And sometimes in RTI, this information is not at all required. It will be behind the window. But let's say hypothetically, this portal will have all the information that is required, and ultimately I would be able to draft a particular piece of what information I want, and this will be submitted. This earlier, which meant that this entire portal I would have the information already saved, but of late this particular design and the program is removed, which means I have to keep uploading my information every now and then. I have to keep giving my name every now and then, my phone number every now and then, my email ID each time I want the information. This frustrates the user because each time I have to give this information. Earlier, one time information on the portal, only the information that I am seeking had to be asked, but now all the basic information is being asked. So this frustrates the user is another point that the author says. Data of applications filed by users before 2022 appeared without a trace. This is being reinforced. This is also kept intact of late but then it has disappeared couple of times, and more first appeals are being filed, which means to say once an information is sought out by the public information officer, this public information officer has to give it at the first level. So I give and ask the information from the first level officer, but this first level officer is not giving the information, or even if he is giving the information, he is not giving the direct information. I ask him an information that this is the circular of the Government of India, what are the recruitments that are happening, why are this circular, but he does not give the information directly. He asks me to go to another department because this department does not have the information, or even if he gives the information, this information is not even answering my question. So what do? I have to file an appeal with the higher authorities. One, because they have given this information which is not enough, which is not meeting my intended standards. What I am seeking for, that information is not given. So I have to appeal. I have to go to the next level of authorities, and this is further irritating the users when it comes to the right to information. Increasingly dissatisfied with the information they are receiving from the public officials, and as a result there are few places where I go on an appeal, I seek the higher authorities the information, but this appeal jurisdiction does not have enough number of people to give me the information. Such has become the bleak state, the pathetic state of affairs when it comes to the right to information, says this article. Added to it, we also know for the fact that when there is a larger lobby that is involved, let's say for example sand mining or minerals, in that case if information is sought out by a person, by the RTA activists, there are cases where elimination of these RTA activists are also taking place. So this article primarily goes on to say that RTI happens to be a major landmark legislation which wants to make sure that there is transparency and accountability in the system. But despite this legislation, these are the issues that have been persisting, and we have to overcome, bring a change into the legislation and also the administrative apparatus, says the author. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says AP students stare at the prospect of losing local quota in educational institutions. We have one of the important articles in the Indian Constitution, which is Article 371D. We have Article 371A, we have Article 371B, we have Article 371C. As part of the assignment, there are the states where the special and temporary provisions are present, which is Article 371A. Article 371A is for which state? Please put it on the comment section. Article 371B and C is for which state? Please put it on this section. So Article 371D and Article 371E is for the state of Andhra Pradesh. What does it do? Article 371D safeguards the right of the local people in employment and education and was created after the agitation in the state of Andhra Pradesh. When was it created? It was created back in the year 1973. It was incorporated as a 32nd amendment of the Constitution. So remember, these two are very important from the preliminary examination point of view. Article 371D is with respect to Andhra Pradesh. Article 371E is with respect to Andhra Pradesh. These are the special provisions for the state. When was it incorporated? 1973. Why? Because there was agitation in the state of Andhra Pradesh, and this was introduced in the 32nd Constitutional Amendment. What does it speak about? President may by order ensure equitable opportunities and facilities in public employment and education to people in different parts of the state. He may require the state government to organize any class or classes of posts in a civil service or for any class or class of civil posts under the state into different local cadres for different parts of the state. He has similar powers vis-a-vis admissions in the educational institutions. What do you understand by this? Let's say for example, there are a couple of states in India. In those states, there are few regions which are comparatively backward. Let me bring another argument for you. If you have seen, you have a particular article called as 371J for the state of Karnataka. What we have is the Hyderabad Karnataka region. Why is Hyderabad Karnataka region relatively backward? That is because when you consider a certain pockets, they might have not been developed relatively in comparison to the other areas of that particular state. If you take the state of Maharashtra, you have the Marathwada region. If you take the state of Karnataka, you have the Hyderabad Karnataka region. So these are the regions within a specific state where they have comparatively been backward in comparison to other areas in that particular state. As a result, these states will have to be developed over a period of time, which is called as intelligible differentia. What is this intelligible differentia? Article 14 of the Indian Constitution speaks about right to equality, but this right to equality is not absolute right to equality. You would be able to also have positive discrimination as well. Positive discrimination how? That in Article 15, in Article 16, you would be able to discriminate people positively because of the historical precedents, because of the historical wrongdoing, and because the state wants to empower and also develop a certain region. So because we have intelligible differentia, that we are categorizing them, we are segregating them, we are compartmentalizing them, we are equating a certain part of a state that they are backward, and as a result they have to be safeguarded. Safeguarded how? You have people in that particular region who have to be given a certain reservation, that only people from this part, this region who have that certificate will be entitled to employment and will be entitled to educational reservation for those people who have the certificate under that region alone. For example, in the state of Karnataka, we have the Hyderabad Karnataka region. In the Hyderabad Karnataka region, if a person is born in that Hyderabad Karnataka region, if he has been living in that particular region for a specific period of time, he will be given a certificate that he belongs to the Hyderabad Karnataka region, and only so and so person will be entitled to the employment opportunity. A certain reservation is given to this section of the people. Educational institutions will have a certain section of these reservation for such and such people, is what is called a special as well as mulk laws. Historically, we have something called as the mulk laws. What are these mulk laws? Mulki laws are, let me write this, these are called as mulk or the mulki laws. What are these mulk or the mulki laws? This basically says that a person from that region is entitled to get certain reservation. Why? Because he knows the culture of the land, because he knows what his culture is, because he knows who the people are, why the people are acting in such a way, and he also knows the language, and he also knows the customs of this particular region. So mulk laws basically says that these are the laws that are present in that region primarily because a certain sense of culture, customs and practices are prevalent in that region. So only those people who know the customs, religion, caste, so on and so forth will be entitled to reservation, so on and so forth. So even in this case, with respect to Andhra Pradesh 371D, basically there are different zones. The state of Andhra Pradesh, there are different regions which are present in the state of Andhra Pradesh. These regions, these zones are comparatively backward. Because they are comparatively backward, they have to be uplifted. So how do a certain reservation? So if they belong to this region, they will be entitled to reservation. They belong to this zone, they are entitled to reservation primarily on the employment as well as the educational parameters. Why am I giving it? Because there is intelligible differentia, that in the entire state, it is only this state, a certain part of the state which is comparatively backward. So on the basis of comparative backwardness, because they are comparatively backward, relative basis, so I am giving them the provision so that they are able to empower themselves, because there has been historical injustice. Not that injustice has happened today, but because historically this region has not been served with the required amount of developmental tools, we are providing them the tools today so that they would be able to come in parallel with other section and other regions of the society, which is why 371D was introduced for couple of regions in the state of Andhra Pradesh. Earlier, the entire Telangana was known as Osmania University region, and the districts from Srikakulam to Prakasam as Andhra University region, while the Rayalaseema and Nellore districts were tagged under the Sri Venkateswara University region, with 85% of the seats in educational institutions reserved for the locals who are from that region, all under the provisions of Article 371D. Now, what is the issue? The issue is Article 371D was incorporated under 32nd, but now there are fears from the fact that Andhra Pradesh Reorganization Act, which had come into force in May 2014, is valid only for about 10 years. This means that the rules and regulations formulated prior to the bifurcation of Andhra Pradesh will not hold good after May 2024, which means to say now we had the United Andhra Pradesh prior to 2004. The agitations were primarily because of Telangana and Andhra Pradesh in the 1970s, and then you had few regions which are comparatively backward, so those regions were provided some sort of local cadre reservation. But now Telangana is a separate state, Andhra Pradesh is a separate state, so and then we have this Andhra Pradesh Reorganization Act which was introduced. Now this will come to an end. All the important rules that have been in existence will come to an end in 2014, in the year 2024, and now there is an apprehension that this may be taken off, that these rules which are present, which are providing certain privileges to the people in this part, may be taken off, is the apprehension. So we have to wait and watch whether it will be taken off. But remember, 371D is basically about giving importance to the local cadre in terms of employment, in terms of educational opportunities, because they belong to that specific region. Now let's look into the next article. This article says the northern plains of India is the most polluted region. The article here is speaking about two important parameters. One is with respect to what is called as air quality life index. The second is with respect to what is called as why there is prevalence of excessive pollution in the northern region of the country. When we speak about air quality life index, this is produced or published by the Energy Policy Institute at University of Chicago. This can be very important from the preliminary point of view. Who gives out this information or this report? The air quality life index report is released, is established, produced by the Energy Policy Institute at University of Chicago. What does it do? It quantifies the causal relationship between human exposure to air pollution and reduced life expectancy. Let me simplify this process for you. Let's say, for example, there is pollution. Let's say the gas chamber, which is defined by the Supreme Court with respect to Delhi. What happens? There is excessive pollution that is taking place in Delhi. So because of the pollution, because of the particulate matter, because of all the releases of the carbon monoxide, carbon dioxide, lead, so on and so forth, there is excessive pollution which we are all inhaling. There is particulate matter 2.5, there is particulate matter 10, so on and so forth. So this, when we inhale, it is obviously toxic. So how will it reduce the life expectancy of a person? A person in a remote village may live for about 80 years, let's say hypothetically, but because the person who is sitting in the city is living for about 60 to 65 years or even 70 years, primarily because of inhaling a lot of polluted air. So the life expectancy is reduced by about 5 years or 10 years or 15 years because of inhaling of this air which is polluted in the country. So this article goes on to say what this air quality index, that is air quality life index, does is it understands and brings into the public viewpoint that because of the excessive pollution that we have in the society and in the environment, we are inhaling it, and as a result of this inhaling of the toxic gas, what is the reduced life of that individual will be brought into picture. So air quality life index fills this gap by estimating the relationship between particulate matter 2.5 and life expectancy, allowing users to visualize the gain in life expectancy they could experience if their community met the latest World Health Organization annual PM 2.5 guideline. So it further goes on to say that there are prescribed parameters given by the World Health Organization. If this is being met by these organizations, then ultimately we would be able to have much better life expectancy. So the Air Quality Life Index is released by the University of Chicago. That is the first parameter. The second parameter that we have to look at is why is the northern Indian plains witnessing more pollution? That is because of the meteorology. Temperature inversions and stable wind conditions are characteristic features of winters in North India. While calm wind conditions prevent the dissipation of pollutant emissions, the temperature inversion layer tends to trap the pollution. So this is because of the temperature inversion. The second point happens to be the Indo-Gangetic plain is essentially landlocked. This is also called as the continental climate. Let me explain this for you. Let's say we have India, the southern part, and then we also have the northern part. What happens in the northern part of India? We have the air that comes, the wind that comes from the western part, and it ultimately gets circulating in this very region. But when it comes to the southern Indian part, what we have is the oceanic influence. So the oceanic influence, there is sea breeze as well. So comparatively, the pollution is less in the southern part of India, primarily because of the oceanic influence. So the oceanic influence will ensure that there is air pollution which is also put out into the ocean. So southern India, the cities have the inherent advantage of the coastal breeze influence that tends to dissipate the pollution. But since in the northern India we have the continental type, there is no oceanic conditions, so the air keeps circulating within the land and sea breeze will not take away the pollution that is existing, and as a result it happens to be a wind convergence zone. There is Himalayas as well. It also prevents the wind from going over it and it completely blocks it. So there is circulation of the air that happens in the northern part, which is another region for it. Added to it, the Indus-Ganga belt in the world's largest stretch of uninterrupted alluvium deposits. As fertile as alluvium is, it is composed of loose unconsolidated particles. Thus, dry alluvial soil significantly contributes to the wind-blown dust. Added to it, let's apply some common sense. What is the saying? One is with respect to the industrial activity. There are a lot of industrial activities that is taking place. Greenhouse gases that are released by these industries. This is another major cause. Then what we also have is the vehicular pollution. The vehicular pollution is releasing a lot of greenhouse gases. Then we have the coal industries that also emanate. These coal industries also give out a lot of pollution as well, and there are dust activities that is taking place in Delhi, and we also know for the fact that stubble burning is also a major cause of pollution in the states like Haryana and Punjab, and also in Delhi as well. These are some of the areas as to why there is excessive pollution. So this article currently goes on to say that if we are making use of this Energy Policy Institute's report, Air Quality Life Index, and we are able to meet the established standards by the World Health Organization, then we would be able to reduce the impact on our health. And at the same time, this information is also given to the public officials who can make use of the information. They would be able to see what is happening with respect to this particular report, and they would also be able to provide necessary information as well, is what is this article all about. So they will provide this information, they will take the information, and they would be able to reduce the pollution in the northern part, is what is this article all about. Now let's look into the next article. This article says campaigning ends for by-elections. What is this by-elections? Let's say for example, every 5 years we have the general elections. So the general elections takes place every 5 years. But what if there is a person who is disqualified? He is disqualified because of the anti-defection law, or he is disqualified because he happens to be a person who is convicted. In all these cases, and apart from that, what if a person passes away all of a sudden? The natural lifetime of a person for this person who happens to be in the general election mode is about 5 years. What if there is a person who passes away? He can be an MLA or an MP. If he passes away at the end of the second year, so there is remaining 3 years. So this 3 years you require the representatives in such constituencies, what we will have is the by-elections. So section 151A of the Representation of the People's Act of 1951 mandates the election commission to fill the casual vacancies in the House of the Parliament and state legislature through by-elections within 6 months from the date of occurrence. So let's say, for example, if a person passes away on 4/9/2023, within 6 months this person's election will have to be conducted again. So within 6 months they have to conduct another elections, and then people will come and cast the vote, and there will be a new person who will be elected for the remaining period. So if a person passes away at the end of 2 years, there will be remaining 3 years. So this person will become an MP or an MLA for the remaining 3 years and not for the 5 years. And this need not be conducted if it is if the remainder of a term is 1 year or less. So the date of provided that the remainder of the term of a member in relation to a vacancy is 1 year or more. So the remainder of a term is less than 1 year, which means to say that if the Lok Sabha elections, the general elections, will happen within less than 1 year, in that case by-elections need not have to take place for that constituency. This is very important from the preliminary examination point of view. Now let's look into the next article. This article here is speaking about Diksha. What is Diksha? This happens to be a portal introduced by the Ministry of Education. Diksha features digitized National Council educational textbooks used by national and state boards. Disha comes under the Education Ministry. It provides e-content for schools, online portal and a mobile application. It is embedded with assistive technology for learners with visual or learning challenges. However, Diksha is a static content depository. What do we have? Let's say you want some textbook that you have to download. You go to Diksha and you would be able to download. Let's say you want to watch some videos. This is a static content video that is provided in Diksha. So you would be able to go to that particular portal and you would also be able to watch those videos as well. So Diksha happens to be an e-education platform that is initiated by the Ministry of Education, where you will be able to download the content like the textbooks, and you would be able to watch few videos that are present on this particular portal, basically to enhance the education. Now, the National E-Governance Division of the Ministry of Electronics is set to integrate personalized adaptive learning into its existing Diksha platform. This software-based approach is expected to allow each student to have individualized learning experience over the course of curriculum based on the unique needs and the abilities. So what we have is a new initiative called as the personalized adaptive learning that will be bridged, and this will become the part of Diksha. Is what is this article all about. So artificial intelligence will be introduced, and each of the student will be able to decide his own learning curve as per his own intelligence. It is this that we have to understand with respect to this topic. So this is it for today. If you're liking these initiatives, please do like, subscribe to our YouTube channel and share it with your fellow aspirants as well. Thank you for watching. All the best.